I'm Paul Ingbretson. I'm a full-time artist and a teacher of painting. I also served as a New Hampshire state representative for 6 terms beginning in 2003. I'm one of a number of concerned citizens, including other former and current New Hampshire state legislators, who are very concerned about the unprecedented usurpation of legislative authority by our Supreme Court in the now infamous Claremont decisions of 1993 and 1997. We've come together to produce a series of podcasts that will lay out the facts and evidence for your consideration. We'll be hearing from some of the best legal minds in our state who followed the issue from the beginning. Our goal is to create public awareness of the serious separation of powers implications of the Claremont decisions, with the hope of generating active public resistance to it and to any future such judicial overreach. Today's guest is the Honorable Dan Itse, who served with me in the New Hampshire House for a bunch of years. Mr. Itse. He served also as the chairman of the Committee on Constitutional Review. And Dan, give us the rest of the name of that committee, and then we'll just go forward about this in this conversation.
Okay, it was the Committee on Constitutional Review and Statutory Recodification, which meant we were supposed to look over the old laws and get rid of reorganize the statutes and get rid of the ones that weren't effective,
Right.
Had no purpose, and in which role I found out the hardest thing to do between the House, the Senate, and the governor was to take out the trash.
Yeah, that was a good. Whose idea was that? Who created that? Was that done under Bill O'Brien?
That was done under Bill O'Brien. It lasted one term. As soon as the other party, the Democrats, took control in 2013, they determined that constitutional review was no longer a matter of concern.
And neither was redress of grievances, strangely enough. Yeah, our 2 committees. Dan also served with me in the legislature's Child and Family Law Committee, and that was very good. Dan's a very effective legislator. Dan, today, I'm talking to you because you have established quite a bit of credibility in regard to the Constitution and your knowledge of the New Hampshire Constitution, as well as the U.S. Constitution. But and you've been very helpful to me in what other follow-up reading you've recommended and that sort of thing, having to do with the greater background and all that sort of stuff. But in particular today, we're talking about the Claremont decision. And maybe I should just ask it to you this way. What's the first thing that pops into your mind that's relevant, that's particularly relevant when we start talking about, I'm using big words like usurpation of power and judicial activism and stuff like that. Where's your head in terms of your background, your sense of things constitutional?
Two things. One, who makes the laws?
Right.
That is, we're talking about the making of laws concerning the funding of education. And the first question would be, who is supposed to make the law? Who has the power to make law and who doesn't? Mm-hmm. And
which
secondly,
means you're trying to say right now that New Hampshire's Supreme Court is making law. That's what you're implying in what you just said.
That is what I am implying.
And then part 2.
Or they are telling, rather than simply reviewing whether or not a particular law is in fact constitutional in their opinion, and theirs is not the only opinion, and nothing in the Constitution makes their opinion so sacrosanct, but they are attempting to tell the legislature how to write the law, which is very different from simply stating that we find the law you wrote transgresses the Constitution in thus and such manner. Yeah. The other thing is that they are trying to use the meanings of words to back their position, and the question is what were the meanings of the words? How did those who wrote the Constitution view the words that they put in there?
Right.
And that's what's important. Madison said, the Constitution must be interpreted according to the meaning of the words at the time it was adopted, or at the time the amendments were adopted. Right. You can't go back and change the Constitution because by how you interpret the words today, how you define the words today. It has to be done. It's in effect a contract in many regards, and the contract language has to be fixed. It can't be amorphous or subject to the drift of time.
Yeah.
You know, one of the things that is really important, oddly enough, it is titled Separation of Powers, Part 1, Article 37 of the Bill of Rights, which is funny because actually none of the articles in the Bill of Rights have any titles. There were none at the time it was written. There have been none actually put in, and the titles tend to narrow what you think the article is saying. So it's very important that you, when you're reading it, you kind of strike out the title. So Article 37 says, in the government of this state, the three essential powers thereof, to wit, the legislative, executive, and judicial, ought to be kept as separate from and independent of each other as the nature of free government will admit, or as is consistent with that chain of connection that binds this whole fabric of the Constitution in one indissoluble bond of unity and union and amity. And that last sentence there, what it tells you is that the Constitution is one complete document, and every article, both in the Bill of Rights and in the form of government, must be in agreement with every other article in the Constitution. You can't take one article and interpret it independent of the rest of the Constitution to suit your own predilections. You have to interpret it in a manner that is consistent with everything else that was there at the time it was put in. So when you're looking at Part 2, Article 83, which is the one where the court found cherish to mean that the legislature had to fund, and it is odd that the Article 83 never mentions the legislature. It only mentions the individuals in the legislature.
Interesting point.
But the word cherish there has to be consistent with the way that Part 1, Article 6, which governs any right to education, because it's a Bill of Rights, right? Part 1, Article 6, the way you interpret Article 83 must be consistent with how you interpret Part 1, Article 6, and what was there in 1784 when they were both originally written, and how the founders who wrote them exercised them.
Okay, right, of course.
Okay, so the judiciary has this tendency, and it's not the only place they've done it, to come back 25, 35, 50, 100 years later and say, the people who wrote the Constitution didn't understand what they put down on paper. They didn't understand what they wrote, and it takes us to properly interpret what they didn't understand they were writing, which is patently absurd. It's a logical non-starter. But unfortunately, as we don't teach logic much these days, people buy into it. And it started, that kind of logic started within about 35 years of the founding. You mentioned redress of grievances. That was how the people lost redress of grievances. The court said, well, first of all, they misinterpreted what was happening. They misrepresented what was happening. And then they went so far as to say that the people who wrote the article on redress of grievances didn't understand what they put on paper, and therefore practiced it wrongly.
Yeah.
And it takes us now 35 years later, who had no part in creating this, to properly understand it. And they've done the same thing with Part 2, Article 83. They've come back now 200 years later, pretty precisely, in the 1990s versus 1784, 210 years later, and said, the people who wrote this thing didn't understand what they were writing, and it takes us to do it properly and correct their error of practice of what they intended. I don't know how you get there.
Under encouragement of literature.
Yeah, encouragement of literature by the legislature. That's another important point, is Sam Adams during the, not Sam Adams, John Adams during the Constitutional Convention for the United States of America was asked, or no, I'm sorry, back up, during the Declaration of Independence, was asked to write for the delegates there what a state constitution should look like. And you see that reflected in a number of the state constitutions, Maryland and Pennsylvania in particular. He then wrote the Massachusetts state constitution, and it was adopted, I believe, without any or with very few amendments, what he put down on paper. He wrote it, and the people approved it. And New Hampshire then took, they had already had one constitutional convention. They actually were before Massachusetts. And that one was not approved by the people. And so then they took and they looked at Massachusetts's, they looked at all the other, they were the last state to create one of what you might call an original constitution, or that founding period constitution. They looked at everything every other state had done. And Massachusetts has a very close analog to Article 83. But Massachusetts says the legislature shall cherish. And when New Hampshire took that general idea and put it into their constitution, they very particularly made the intentional change from legislator to legislators.
Yes, and I remember the conversation we all had way back then about whether you and I, Dan, had somehow to pay for public education and to pay for an adequate public education because we're the legislators.
Right. We discuss it, we're supposed to cherish it, we're supposed to cherish education, but obviously you don't expect the 400 people in office at a time to reach into their pockets and pay for the state's education. That would be patently absurd. Right. So it can't logically flow that the legislators cherishing education must somehow be linked to funding. They can't fund it personally.
Yeah. Well, that's a really important
point. They can
point.
write laws regarding funding, but how did the founders do it?
Right.
They wrote a law that said each town must raise at least a certain amount of property tax to fund education. Didn't prohibit the towns from raising more. Mm-hmm. They just set a floor. Mm-hmm. You will raise this many pounds of silver per valuation of property.
And I remember if you didn't get it done, the money would come out of your pocket. The state had the authority, took the authority upon themselves to force you personally to lose property to pay for it.
Yeah.
So that's a very different construct.
So, and that's one of the things that was lost until 1968. The Part 1 of our Constitution, Article 6, said that school funding was the exclusive power of the towns. In fact, there's a list. Towns, parishes, bodies, corporate, and religious.
That's in Article 6.
So towns is in there, so it refers to your town public school. It refers to, when it talks about bodies, corporate, and religion. Bodies, corporate refers to towns, as towns does. It says towns, parishes, mm-hmm. bodies, corporate, and religious. During the early periods of our state, and actually until very recently, I got that changed. But the unsettled regions of our state were settled by churches. A church would go in and would act as the town body. And so they did put in, if the church settling the area was a Baptist church, it would be a Baptist school. If it's a congregational church, it'd be a congregational school. One of the caveats in Article 6 was nobody can be compelled to pay for a school of a different denomination.
Yeah.
So if you were living in the town but you weren't actually a member of the church that was functioning as the governing authority, then you didn't have to pay the school tax.
Interesting. Dan, let's talk about rights, though, under Article 6. This is that section, right? And we're talking about something that duties, rights, whatever those things, definitely are not part of the hortatory part of the Constitution. That part that includes Article 83 was all in that class of things we want to cherish and aspire, aspirational language that shows up all over there. I had a question from a constituent formerly, I think, of yours, and I won't mention her name, but it was a very good point. She says, haven't we just, with what's happening in Claremont, the 93 and 97 decisions in Claremont 1 and 2, aren't we losing a right? The right to control education locally. If the state takes over education, now, so talk about that. If the state takes over education, whoever pays for it controls it. We just have lost the right to local education, which was more than a right. We were told we had to do it, but et cetera.
We were told we had to do it, but it was also the state's, the towns, parishes, bodies, corporate, and religious shall have the right to contract with their teachers and provide for them.
Yeah.
And at that time, since you were dealing with the one-room schoolhouse format, which I actually know you actually grew up in,
did.
A one-room schoolhouse, the teacher was the curriculum, essentially.
Yeah.
I mean, the teacher chose it. There was no superintendent or principal or whomever to choose what the curriculum was going to be. It was the teacher, because the teacher was the chief cook and bottle washer.
So let's just talk about this. The word abuse. Let's talk about that, Dan. Let's settle on that part, just out of Article 83. Cherish and adequacy. Talk about those things as it relates to the way you think of the Constitution. Where did they get the word adequacy, for example?
Well, first, what does adequate mean? Adequate means that which is bare, and adequate does not appear in the Constitution.
Huge point.
It is not there. Adequate means that which is barely sufficient. It's the lowest bar there can be. Okay? So you have a situation where the Part 1, Article 6 says that the towns have the power to contract with their teachers and provide for them, essentially pay for the school.
Yeah.
And Article 83 says whatever the legislature does, they have to always remember to cherish. And cherish is not the only thing in that list. And that's something that shouldn't be lost on us. It is a laundry list. So let's just look at that list and see if it makes sense that cherish means pay for. It shall be the duty of the legislators and magistrates. So it's not just the legislators.
Right.
First of all, it's the magistrates. Magistrate is pretty much any public official. It's a judge, but it's also the town selectman. It's the governor. It's his subordinates. Magistrate is basically a government official. In all future periods of this government, to cherish the interests of literature and the sciences, and all seminaries, that's religious schools and public schools, to encourage private and public institutions, rewards, and immunities for the promotion of agriculture, arts, sciences, commerce, trades, manufactures, and natural history of the country. Well, first of all, and then that's a long list. So we're supposed to pay for all those things from the state, okay?
Well, especially seminaries.
And promoting them.
And that's still in the language. The supporting of seminaries is still part of the Article 6.
Right. Well, here's a fun one that just came to my mind. I'm just trying to find it. The so-called Blaine Amendment. which is, provided nevertheless that no money raised by taxation shall ever be granted or applied to the use of the schools of any religious sect or denomination. So if cherish means pay for,
Right.
and Article 3 says the legislators must cherish seminaries and public schools, can you rationalize that it means pay for one and not for the
No,
other?
you can't. Obviously, you can't. It's one of the great problems with this whole thing. It's just nuts.
I mean, it falls apart. I mean, that's all. It falls apart in the same article. You don't even have to go to Article 6 as originally written for it to fall apart. It doesn't hold water. It is judicial opinion. Remember, they're called opinions. It is a judicial opinion that holds no water. It is not self-consistent, let alone consistent with the balance of the Constitution.
Right.
It doesn't, the way they interpret cherish in Article 83 relative to public schools is not the way that Article 83 interprets cherish relative to seminaries.
Well, you're saying it's not.
And remember,
It's not even the courts couldn't say that because they would be in the
Right.
face of the Blaine Amendment in
Right.
in Article 6.
no, Blaine Amendment's in Article 83.
Oh, it is?
It's in 83.
Okay. Sorry.
Those
why
two
you're here.
sentences are three. Those two sentences are three sentences
Oh, yeah,
apart.
yeah. I'm looking at it.
Or those two clauses.
Yeah.
I mean, they just didn't read the whole article. I mean, it is a decision with a political agenda.
Yeah.
And when you have judicial opinions with political agenda, they have to go to great contortions and throw out all prior decisions. Do you think this is the first time education funding ever came up as a matter of public review? It's no different than having to turn the Constitution on its head to get rid of petitions against the judiciary. It's no different than Roe versus Wade at the federal level, which threw out all 150 years of precedent.
So, Dan, why do you think they went to, we know that they went to Kentucky and to Massachusetts for this decision. Do you have background on that? Is that something you can?
I don't have background, but if I can say, why did they go to Massachusetts? Because Massachusetts says legislature.
Yeah. Yeah.
I mean,
yeah.
that.
But my point to you is you're looking at the Constitution and thinking, what are they doing grabbing somebody else's Constitution? That's what you're thinking, right?
And the Constitution of Massachusetts and Kentucky have no relevance to the laws of New
Exactly,
Hampshire.
right. So were they looking for some sort of a curious precedent in some other states? You know, that's the sort of thinking that goes in my mind. Why would you look at another state
Yes.
for precedents? It's just nuts, you know. Unless we know that at the time there were a lot of states were trying to get this kind of control. They were trying to get the states to totally take over public education.
Right. It's 1968. Prior to getting rid of the prohibition or the mandatory local funding of education in Article 6, the vaunted Augenblick formula
Yep.
would not have been constitutional under the state of New Hampshire's Constitution. But you amend Article 6 so that school funding is no longer exclusively local, and now the state can start funding teachers. Notice that it did say providing for teachers, so for some 100 years before that, the state had been assisting in building schools,
Yes.
physical structure, but not paying for the teachers because Article 6 prohibited it.
Right.
And people didn't even really realize what was being taken out because when they amended Article 6, and we don't have it up there, but originally read to the effect that the purpose for public education was to teach evangelical principles. And I have to say, when I first really started studying the Constitution in detail, it bothered me. I was wondering why that was there. Okay, you have it. Part 1, Article 6 is in the first 10 articles.
Right.
And the first 10 articles are all about, fundamental liberty. Government's accountable to the people. You give up certain rights in the exchange for the exchange of, you give up certain rights of the Constitution in exchange for the protection of other rights. Without the exchange, the surrender is void. The obligation of revolution if the government goes awry. Mm-hmm. Okay, these state sovereignty. These are the things that are in articles in the first 10 articles. And then you have Article 6 in there sandwiched in between all this stuff. And why are they talking about evangelical principles? Right. What did they mean by evangelical principles? And I thought about it long and hard. And I suddenly I thought about what I grew up in congregational church, and what made it different from non-evangelical churches. My first thought was the Roman Catholic Church. And the point was that the evangelical churches are governed bottom up.
Yes.
The in one manner or another, the congregation chooses its pastor. In a canon law church, which is the alternative, which is certain Lutheran churches, it's the Roman Catholic Church, the pastors are assigned top down. And it suddenly occurred to me that what they were referring to was the principles of bottom-up government, church and civil. Huh. No, and it's not, shouldn't be lost that evangelical is spelled with a lowercase e, not an uppercase e.
Yeah.
Okay, so they were talking about, and then you go further down in that article, and it required that all the teachers be Protestant. Now, this is a period, New Hampshire was a Protestant state. You had to be a Protestant to be in the legislature, or to be governor, or in the executive council, and you had to be a Protestant to teach public school, because they wanted to teach these evangelical principles of bottom-up government.
Yeah, very good. Dan, how are we getting far afield here? Take us back.
Oh, we're not getting far afield.
Yeah,
so,
clarify.
Along comes 1968, and they change evangelical principles. The amendment changes evangelical principles to high principles, which doesn't really mean anything.
Like adequacy.
And it strikes out all the religious or semi-religious language out of Article 6. Right. And buried in the middle of that religious or semi-religious language is paying for the schools at their own expense.
Yeah.
So the target, getting rid of the exclusivity of local funding, was gotten, the reason they said for the amendment was to remove obsolete sectarian references. They never said a word about changing the nature of public education.
Ah. So Dan, in that case, was this a printing problem? Or what happened actually? Why did this happen? I mean, it was stricken. Was it just somebody in the legislature was
No, it is the form of the amendment. Unfortunately, the amendment was really a heavy-handed red pen. They really just, except for changing the word evangelical to high, pretty much everything else is just crossing out language.
They didn't, so they didn't accidentally cross that part out.
No, it's just buried in the middle of the removals. Yeah. And it actually ends up, the original form, which I don't have here ready to read to you, which is a very elegant sentence.
Right.
Ends up, or a series of sentences, ends up being actually linguistically nonsensical.
Right.
Let me just, I'll read it to you and then show you the disconnect. As morality and piety, rightly grounded on high principles, will give the best and greatest security to government, and will lay in the hearts of men the strongest obligation to due subjection. And as knowledge of these is most likely propagated through a society, therefore, the several parishes, bodies, corporate or religious societies shall at all times have the right of electing their own teachers and of contracting with them for their maintenance or support or both. So one, they struck towns out of the list.
Huh.
Towns were originally in that list, but you're therefore, okay, therefore means it's a dependent clause. And it says that because propagating these things throughout the society, the towns, or everybody but the towns, will have the right of electing their own teachers and contracting for their own support. What it used to say was that for propagating these principles, therefore the towns parish, therefore we will have public education.
Yeah.
So and therefore it is necessary that you have a way of teaching these principles throughout the state. That's a logical sentence. Because these things are so important, we must have a way of teaching them.
Yeah.
And then go in, and so you strike towns out of the list, so it no longer applies to public schools and only to religious schools. And you because you're just doing this with a heavy-handed red pen, you end up with a sentence that makes no rational sense. Why does electing your own teachers and paying for them at your own expense in religious schools guarantee the spread of these principles? It doesn't. Having schools to do it does.
Well, Dan, so we're talking about Claremont. Let's stick with this. Let's just narrow this back down. Let's get it right on top of Claremont. What were the?
Well, then now we know the background. Now narrow it down.
Yeah.
You have judges who were angling for two things. One, they wanted state-run education. They wanted cookie-cutter education all across the state. And we believe they wanted to force an income tax. One of the things that you do, if you make the expenses of government too high, you have to have a broad-based tax. New Hampshire has managed hitherto to avoid a broad-based tax at the state level. And what happens when you have a broad-based tax? All of a sudden the people have absolutely themselves no control over taxation. When all the money is raised at a state level and doled out to the cities and towns, the people have no control over how much they're going to be taxed. That's one of the things I've always told people, is that the property tax, as onerous as it may be, is beautiful in the sense that you're taxing yourself. You vote when you go to town meeting, or now in an SB2 town, you go to the ballot and you vote to make appropriations. You are taxing yourself.
Yeah.
If you want lower taxes, vote to spend less money.
But Dan, you're saying that they actually had that as an agenda. What evidence do we have of that? I mean, it's one inferred. We all infer it.
It's circumstantial.
No, how else would they get involved? Except that one part when you're saying they wanted a broad-based tax. I mean, I'd like to know who they is, and did they say somewhere that they wanted a broad-based tax? We know the Democrats have historically always wanted it. I don't believe they did.
Yeah. I don't believe they said it, but they push for a system that, if allowed to go to their logical conclusion, would have required it.
Yeah. So you're thinking they were thinking that far ahead. Potentially. I mean,
Yes,
yeah,
I
yeah,
believe
potentially,
so.
yeah.
There's every evidence they were. I mean, you don't. It was well thought out enough that you had the amendment to Part 1, Article 6 in 1968, and you didn't have the Claremont decision pushing it to the state level mandatorily until the 1990s. So yeah, I believe it was that well thought out. It was the trend of society at the time. It's the period when the Federal Department of Education was created.
Yeah, yeah.
I mean, don't forget, there was no Federal Department of Education prior to 1978. So, I mean, it is the trend that those who imagine themselves to be the elites were pushing for at that period.
So in some sense, you would say these guys were, in theory, they were saying we know that public education from about the 60s started seriously failing. It was already in trouble before that, but it was seriously failing. And to put a positive construction on it, all these judges were thinking, now let me follow, hear me out. These guys are thinking, we got to do something about this. And it was all about, they need more money. The reason they're failing is they need more money. That seems to be the underlying logic of this whole thing. And when these guys come marching in from Claremont, if I'm understanding those situations, they need more money was the underlying principle. They need more money. Well, so that's all very positive. That's all very nice. But it's so completely silly because ever since then, I don't know if you've seen the numbers, Dan, but education quality has flatlined. There is no improvement in education. We've tripled in the amount of spending we're doing. Statewide, and nationwide.
Nationwide, and I would say it hasn't flatlined. I'd say it has decreased substantially.
Yeah.
Just look when you and I went to school, and when you went to school, and even when I went to school, because you're my senior.
Yeah.
We were number one in the world.
Yes, it's true. Yeah.
Okay, 1976 is when I graduated high school, and American education was number one in the world.
Yeah.
And then you create the Federal Department of Education, and it has been in decline ever since.
And not a thing these judges can do to distort our Constitution has improved it in any way.
in any way whatsoever.
But it has fully distorted our Constitution.
If you look at the state New Hampshire education, in the 1990s when I moved here, we were among the top in the nation. And granted, a nation in decline, but we were among the top of the nation.
Well, we're still like fifth from the top, but it's such a we're such a failure. It means nothing.
Well, you look at what we knew graduating high school, and what the average high school kid knows today, and it is abysmal. It's abysmal.
Well, we had the dean of the Harvard, of the university system in New Hampshire in our education committee. He said we're now graduating, and he was talking about the dilemma you just mentioned. Yeah. He says we are now graduating illiterates from University of New Hampshire.
And why do they graduate them?
Well, you're talking about let's not get into the weeds here. but the money isn't helping. Is my point. The amount of money that they're forcing.
No, the money doesn't help. But I mean, there's a logical disconnect there. Yeah. How can the dean of the college of the University of New Hampshire say we're graduating illiterates? How can you graduate an illiterate from college?
Yeah. Well, even if he weren't, even he was just talking about high school, and my memory is that he was talking about college.
How can you graduate an illiterate from high school?
Exactly. So anyway, but you see what we're talking about. We're talking about these guys trying to fix something in theory, and yet they wind up doing something really dastardly, in my view, and that's why you're here. Because what are they doing? They're actually now tell me I'm wrong, but they're now changing the Constitution by interpretation.
Absolutely, that's exactly what they did. And the other important thing is to understand how our government works. Remember when I read that article on the Article 37?
Yeah.
the powers of government to wit the legislative, executive, and judicial. They are always in every American Constitution, all the states, the federal, they are always listed in that order.
Yes.
And that's not accidental. Yes. It is because when they organized our Constitution, they gave the most power to the legislature.
To the people.
To the people. And within the legislature, they give the most power to the House of Representatives.
Yes, which is the closest thing to the people. Yes.
Only we can initiate removal from of a member of another branch from government. Only the legislature can remove members of the other branches. The other branches can't remove the members of the legislature.
So that's the very nature of a republic, and that's my argument about all this stuff. We're losing the judicial oligarchy is trying to take over the republic, destroy the power of the people. Is that a goofy reading?
No, well, whether it is the intent or not, I
don't care about intent.
Judges are no different. Judges are no different than other people.
Yes. Yeah.
And people tend to love power.
Right.
The judiciary has been accreting unconstitutional powers to itself since early in the republics.
Yes. Yeah.
Whether it's judicial review, you only have to look at how they did judicial review in the first decade of our republic versus how they do it now to see that the way it's done now is not how it was intended.
Yeah.
Our Constitution says only the legislature has the ability to nullify a law. The judiciary can't nullify a law. That's a
they
legislative
can offer an
act.
opinion about it.
They can offer an opinion about it. They can strike a law down in a single case. They can't take the law off the books. They can't cause the law not to be practiced lawfully.
So define that better. What power do they have?
Well, okay. In the quintessential case is the 10-Pound Act.
Okay.
And at that time, Article 20, Part 1, Article 20, said that you had a right to jury in all cases. And the legislature passed a law that said if the case, this is a tort case between two individuals, and that's what we're referring to here. That's what Article 20 deals with. That if it was less than 10 pounds, you could go right to the justice of the peace, which was not a jury trial, it was a hearing. And in one of these cases, the issue was a fellow who had been given a pair of shoes on credit and not paid for them. And the shoes cost less than 10 pounds, so he went to the shopkeeper went to the justice of the peace, and the judge in the case found in favor of the shopkeeper, so it was appealed to what was then called the Superior Court, which is the equivalent of our Supreme Court. And they got to the end of the case, and they were going to file in favor of find in favor of the shopkeeper, and the customer's lawyer got up and said, "This is unconstitutional. I had a right to trial by jury in the first case, in the first instance, via Part 1, Article 20, and the judges then found in favor of the shopkeeper and arrested their decision on the fact that the 10-Pound Act was unconstitutional." Mm-hmm. So basically, they stayed their decision on constitutionality. This then began to happen. All the courts in the state, having had their eyes thus opened, would accept cases pursuant to the 10-Pound Act. At the conclusion of the case, before the presentation of the decision, one of the parties, presumably the loser, would stand up and say it's unconstitutional per Article 20, and the judges would then arrest their decision. So it was all done on a case-by-case basis. The judiciary never presumed to say that the 10-Pound Act couldn't be practiced, and they continue to accept cases under the 10-Pound Act.
Yeah. That's extremely
and then
limited.
at the conclusion,
yeah.
found unconstitutional, the legislature then attempted to impeach the judges who were thus finding, and failing to impeach them, they repealed the 10-Pound Act.
Okay. Yeah. No.
That's proper judicial review and interplay between the two branches.
Yeah, it makes a lot of sense. Yeah.
It does.
So, I presented this to some others as well, and I think this is from Van Loan's conversation. Just listen to this, Dan. This is called he describes this as the court's thinking process. They say the breadth of the meaning of these terms, duty to cherish, together with the articulated ends for which this duty to cherish is established, strongly support that the duty to cherish the public schools encompasses the duty to provide an education to the people of the state. It is reasonable, therefore, to understand that the duty cherish public schools as a duty to ensure that the public schools achieve their object and educate the people. I mean, have you ever heard anything more contorted than that?
They call that circular logic.
Yes. Well said. That's exactly what Van Loan said about it as well.
And it fails to recognize the fact that, therefore, cherish does not mean the same thing for public schools and seminaries in the same article.
Yeah. You can't get there from here without being totally inconsistent. Yeah.
Right. Well, it means it in the first instance, but it doesn't mean it in the first instance, but does mean it in the second instance.
Yeah.
I mean, that's not even a logical progression.
No. Now, you can't expect anybody to respect your opinion if you change the definitions in the middle of the discussion without notifying anybody. One of the other things I want to mention is that these judges involved was Chief Justice Brock, who was nearly impeached for corruption, William Batchelder, Sherman Horton, who had a good reputation until then, William Johnson, and a retired justice who was 82 years old, William Alvan Grimes, who stood in the place of Stephen Thayer III, W. Stephen Thayer III. I'm just mentioning that because it's important for people to know who these people are. What is your sense of my things? One of the things I'm trying to get people to discuss is why the Supreme Court, the present one, doesn't go ahead and back off from all this stuff, because their name is going to be on this list going forward as we get into deeper and deeper into income taxes and broad-based taxes. Their names are going to be totally attached to it, and it's going to be a slur on the entire Supreme Court and the judicial, what do you call it, egalitarianism in general, the oligarchy.
Paul, do you have a copy of the decision right there?
I can get one. I don't have it right here.
Because I believe there was one judge who dissented or partially dissented.
That was Horton, and that was in the 97.
That's what I thought. I thought it was
97,
Horton.
Not the 93 one. He was one of the five in 93.
In his dissenting opinion, he made a linguistic reference to preparing the people to be I'm struggling with the actual language, but he used phrases referring to the people as the capital of the state.
Okay.
Human capital.
Okay.
He uses the phrase human capital in his dissenting opinion.
Interesting. Yeah.
And the phrase human capital is a term exclusively of the socialist.
Wow. And he's using that in a positive frame, like his own sense of things was that that's who we are?
Well, he said that was he was saying that was the intent, was to make the people of New Hampshire suitable human capital for the state.
And
I'm paraphrasing now because I'm doing it from memory that's 15 years old, probably.
Yeah. Boy, I don't remember any such thing. Yeah.
Look, if you can get a copy of it in a searchable form, search for the word capital.
Right, right, right.
Or some fraction of that word, and you'll find it. And it's one of those things that is bone chilling, because it tells you their frame of mind as to how they were thinking of the people and what the purpose of the Claremont decisions was to ensure that it would produce citizens adequate to the perpetuation of the state.
Well, that's very different from having a state that's adequate to the expressed desires of the people, isn't it?
Yes.
to express.
And
the
that's
desires.
one of the things that exposes this long-term agenda and the oligarchical nature of the decision.
Yeah, yeah. So your sense of it is much like many of us, that there are a bunch of guys who think of themselves as pretty special, never elected to anything in their lives, and they are going to tell us how it's going to be, even if they have to interpret the Constitution to something it wasn't. Whereas our founders were all everything they were about was how to keep that from ever happening. How do you keep it? How do you keep the power with the people? How do you keep the power? So you set it up so that the legislature has all the control of the money, has all the control of the law, and has, in the early days, control of the courts, and dissolved them numbers of times. I mean, what could be further from the reality?
Until 1974, they had the power to dissolve the courts, and did when the courts got out of hand.
Which is now, yeah. So, Dan, have you got any, in a summary sense of this whole thing, give a constitutional review, based on your general sense of Claremont, and the two or three points you started talking about at the beginning, but I'd love to have a summary, whatever version you'd like to give, some sort of a summary sense of the Claremont decisions.
Well, the summary sense of the Claremont decision
vis-a-vis the Constitution, how it relates to the Constitution,
is that they are contrary. It's funny when you think about it. In Part 1, Article 5, the Constitution gives the legislature great powers to make laws, statutes, etc., provided that they are not repugnant to this Constitution or the Constitution for the United States of America. And I would say that the Claremont decisions are repugnant to and contrary to the Constitution of the state of New Hampshire. They are not just extra constitutional, they are contrary to the intent and the written word of what is in the Constitution. And while the amendment to Article 6 may have made that those intents less visible, if you go back to what was in the Constitution at the time the word cherish was put in the Constitution, you cannot arrive at the conclusion they arrived at. Part 1, Article 6 obviously applied to towns, which meant it applied to public schools, which means that cherishing public schools in Part 1, Article 3 has to be understood within the context of Article 6 as originally written. Right. And therefore, the funding of teachers in particular and education in general is a local decision, or a local obligation, not a state obligation. And even if the state chooses to send money to the towns for the purpose of education, it is not an obligation. And there is a big difference.
Right, yes. And the second part of it is, according to our friend, and I don't disagree even a little, that we have just lost the right to self-control, to local control. If the state is actually forced, if they actually write it into law, that they are going to do the job of supporting education, they are definitely going to have to take the responsibility of controlling it. Which means we lose at the local level.
What else has been lost? What has been lost is the fealty of the legislature to the people they represent and giving that fealty to the courts.
Yeah.
The Constitution of the state of New Hampshire, and for that matter, I don't know of any constitution that does in America, give the judiciary any authority to tell what laws the legislators must write. At most, it gives them an opportunity to determine that a law written is unconstitutional, but our Constitution certainly does not give them any authority to tell the legislature to remove that law, though it be unconstitutional.
So the bottom line, you're talking about the failure of our legislature to protect us.
Yes.
To protect our law-giving rights, to protect our taxation rights.
Yeah. It is a failure of the legislature to stand up for their power delegated to them by the people in the Constitution.
Right.
Remember, the power of making laws fundamentally is not a power of the legislature, it's a power of the people, which has been delegated in our Constitution to the legislature.
Right. And they're letting us down.
And the power of enforcing those laws has been delegated to the executive.
Yes.
And the power of adjudicating those laws has been given to the judiciary. And for one branch to assume or presume the powers of another branch is an aggression upon the people.
But that means then, and we only have a couple more minutes left, but that means you also agree that the courts are not the final arbiter of the Constitution.
No,
they claim it. They
arbiter.
claim it. Somebody, I think even Attorney Lehman, he said, well, somebody's got to be the last word. Well, in a republic, why wouldn't it be the people who are the last word? That's my argument.
Well, that is what the Constitution says, New Hampshire Constitution. And this is a great note to end on. It's Part 1, Article 38, which originally was the last article in the Constitution, in the Bill of Rights. Right. And again, it's titled Social Virtues Inculcated. Right. But having no title, let's read it for what it is. A frequent recurrence to the fundamental principles of the Constitution and a constant adherence to justice, moderation, temperance, industry, and frugality, and all the social virtues are indispensably necessary to preserve the blessings of liberty and good government. The people ought, therefore, and ought is a strong word, we'll get there, ought, therefore, to have a particular regard to all those principles in the choice of their officers and representatives, and they have the right to require of their lawgivers and magistrates an exact and constant observance of them in the formation and execution of the laws necessary for the good administration of government. Mm-hmm. Principles here. Ought is the highest structure. Ought isn't should. Mm-hmm. Ought is duty.
It's a moral thing.
Ought is what you must do because it is the right thing to do. It is giving the people the charge to know those principles of the Constitution and use them in choosing who they have as their lawgivers. That's the legislature. And their officers and representatives. So that's the governor or those who are elected and their representatives. That's senators and representatives. And they have a right to require. That's the people have a right to require. And if they're doing the requiring, they're doing the interpreting.
Yeah.
Of their lawgivers and magistrates, and that includes the judges.
Yeah. You've made your point. The people have the right to be the ultimate. Dan, I want you to end with a comment on Article 11, on HCR 11. You probably don't have a copy of it in front of you, but HCR 11.
Oh, I know.
Now I'm going to read you this portion. I just want you to react to it, though, if I can get this big enough to actually read here on my computer. The Article 11. It says in the summary, it says declaring the directives of the judicial branch in the Claremont cases that the legislative and executive branches define an adequate education, adopt standards of accountability, and guarantee adequate funding of a public education are not binding on the legislature and executive branches. What's your reaction to a House concurrent resolution between the Senate and the House, obviously, that says that the legislature and executive branches define an adequate education? I'm sorry, that the directives of the judicial branch that they should do all these things are null and void. They aren't binding on the Constitution, on the legislature. How do you react to that?
Well, they're about 30 years too late.
Well, we did try to pass it. Yes, this is the same. Same bill.
We did, and I co-sponsored it, and it's important. And here's a logical issue. How does the judiciary enforce their order?
Right.
Okay. The Constitution, Part 1, Article 32. No. Article 30. The freedom of deliberation and speech and debate in either house of the legislature is so essential to the rights of the people that it cannot be the foundation of any action, complaint, or prosecution in any other court. Remember where the
court, yes, Supreme Court,
the general
including
court.
the Supreme Court, yeah.
So remember, the legislature is the general court. In any other court or place whatsoever, no place else in the state.
There it is. Yeah.
Okay.
Yep.
So, what does the judiciary do if legislators don't vote to do their bidding?
Well, that's where we are.
Nothing
they can do about it. Yeah.
They have no lawful authority to take any action against the legislators. They can't put them in jail. They can't fine them.
They don't have a right to dictate to the people how they should tax and how they should define education and how they should interpret the Constitution, Dan?
Obviously, if the judiciary can't enforce their opinion upon the legislature, they have no authority to make such an opinion.
Right. Yes.
Okay. It's worth every scintilla of the paper that is written on, and it's just as good for toilet paper as it is for judicial.
Beautiful. Well said, and a great note to end on, Mr. Itse. This is the Honorable Dan Itse and Paul Ingbretson signing off. I think I'm going to have another ending on this show, but thank you, Dan, for being here today. No, not a different ending. That's a very substantial ending. It's the key ending. What can they do about it? But thank you. Thank you so much, Dan.
Yep.
If you're as concerned as we are with the loss of the legislature's control over policy and taxation in New Hampshire and wish to help, please share these podcasts with as many people as you can, and then consider donating so we can bring you and your friends even more of the important facts concerning our Supreme Court's Claremont decisions.